Hi, Tony DeWitt here, Missouri appellate attorney and a guy who likes to make the law make sense on YouTube. When does a business have a duty to protect a patron from the acts of a third party, specifically the criminal acts of a third party? That's the question that the Missouri Supreme Court answered in Harner versus Mercy Hospital of Joplin. Now, for those of you who may not be real familiar with the Missouri area, Mercy Hospital Joplin is the hospital that was lifted off of its foundation by the Joplin tornado several years ago. It's a really big hospital. It has a really big parking lot. And in this particular case, the issue for the court is whether or not a duty existed. The way these things usually manifest themselves is if there is a question about duty, the defendant will file a motion to dismiss. And if the motion to dismiss is granted, then the plaintiff will appeal and you get a ruling pretty quickly. But in this case, if there was a motion to dismiss filed, it was denied. That isn't really set forth in the opinion. But what is set forth in the opinion is what happened after the trial was over, where you have a full record and then the court can make a ruling on the basis of the full record instead of merely the allegations. So in this particular case, we're talking about a judgment notwithstanding the verdict, meaning essentially, yes, this whole case was presented to the jury, and the jury found the facts necessary to issue a $2 million award against the hospital. The hospital then filed this motion for judgment notwithstanding the verdict, and that says that the jury may have found those facts, but there was no duty that the hospital had to protect its visitor in this case. There are several people here who are subscribers. I know Bill and John are two of them. And they have worked in a hospital. And if you've worked in a hospital for any length of time, you know that sometimes people who are bent on killing someone will follow the patient to the hospital. They'll actually ride right behind the ambulance to make sure they get the job done. A good friend of mine by the name of Bill Nilsson, who I haven't seen now in probably 15 years, Bill was in a hospital in New York State that must remain nameless, and they received a trauma code. And this was a gentleman who had suffered multiple gunshot wounds. And they were in the emergency room and working to try to save this man's life when a guy came in with a very big weapon and pointed it at the doctors and the nurses and said, "Let him die." Well, you know, when the only weapon you have is an oxygen hose that you can wave at somebody, the likelihood that you're somehow going to overpower somebody with a handgun is not very good. Bill did something that I think of to this day as being quite heroic. He was at the head of the bed, and there is a little connector on the EKG machine, and it has three little leads, three little wires going into it. So he just grabbed that connector and he pulled one wire, and the machine started to go haywire. And then he started tapping on the other wire, and so it was doing the little, up and down waveform, and then he just pulled both of them. And of course, at that point, the thing went straight across, indicating that, it wasn't receiving a signal. But of course, the person with the gun thought that meant the guy had died. So he was satisfied. He turned around and walked out of the hospital. And I guess pretty soon after that, he was running out of the hospital. And as soon as he was free of the area where they could see him, they immediately plugged the monitors back in and went back to saving the guy's life. But I've seen, in my own experience, I've seen people trying to commit felonious acts in a hospital against someone else that was there seeking treatment for acts that had already taken place. It does happen, and working in a hospital, although it is generally a pretty safe thing to do, it is not always a safe thing to do, particularly in the emergency department. So what we have here, this is the introduction, and it says that the Mercy Hospital appeals from this judgment. Harner claimed that it breached its duty to protect him from the criminal acts of a third person on Mercy property. And then the court says because he failed to make a submissible case, in other words, he didn't have all the elements proved for his case, under the known third person exception to the general rule that businesses have no duty to protect people who come to the hospital from the criminal acts of third persons, the court has jurisdiction, and it holds that he failed to make a submissible case. So he lost his $2 million judgment. I'm sure Mr. Harner is very upset about that, but let's see whether or not we think that's the right answer. So in December of 2015, a gal by the name of Kalia Liska arrived at Mercy via ambulance with her boyfriend, who was to receive treatment at the hospital. After waiting for her boyfriend inside the hospital, she got anxious and wanted to leave, and so she left the hospital at about 8 o'clock for the hospital parking lot. In the parking lot, she approached a guy by the name of Floyd Bennett. He's a 79-year-old man waiting in his car, and she asked him for a ride. And Bennett says, "Nah, sorry, not interested." So she walked away, but she stayed in the parking lot. Bennett did not report that incident to Mercy because he believed she was more of an annoyance than a threat. Then at 8:04, Liska entered an unlocked vehicle belonging to Keith and Elnora Wooldridge. This is fairly common in southern Missouri. Most people are fairly honest, and parking lots in a major hospital are usually very well lit. And in this particular case, even though it was well lit, nobody noticed that she entered into this person's car. So the Wooldridges were inside the hospital, and when they came out about 20 minutes later, Keith Wooldridge opened the door and said, "Lady, I think you're in the wrong car." She didn't say anything. She just exited the vehicle very quickly and ran away, taking a case of medication from the vehicle with her. And she told the cops later on that she was going to sell the medications. The Wooldridges immediately went back in the hospital and reported to Mercy, to the employee by the name of D.D. Baker at the front desk, that someone had been in their car and that they'd been robbed. So they called security. Security came and looked around and called the report in to the Joplin police. At this point, Officer Meyer arrived at the front desk and spoke with them, and then the Wooldridges told him they'd been robbed. He testified that they described it as a theft. Nothing that they told him suggested that Liska posed a threat to anybody at Mercy. In other words, they didn't say, "She robbed me at gunpoint." They didn't say, "She robbed me at knife point." They just said, "She grabbed our stuff and ran." The security people conducted rounds, and Meyer went out to inspect the vehicle. After his last round, Lacombe stopped at the Wooldridge's vehicle to inspect it and discussed the incident with the police officer and Mr. Woolridge. Officer Lacombe left the scene at 9:01, parked the security vehicle, and entered the hospital. Meyer returned to the hospital with Keith Wooldridge at 9:04, then left to patrol the parking lot at 9:13. Meanwhile, Liska remained in the parking lot after leaving the Wooldridge's vehicle and went back to that 79-year-old guy, Bennett, and asked him for a ride. And again, he said, "No, I'm not interested." So she walked around the parking lot until she found another unlocked vehicle. This one belonged to Harner. Harner testified the driver's side door of his vehicle didn't lock, but he had a vehicle alarm and that it would sound and flash if somebody got in. Before going into the hospital, he left his Ruger 380 pistol, which was loaded and had no safety, in either the center console or the glove box. He wasn't sure which. And he did that because Missouri statutes require you to leave any firearm in a car. You cannot take a firearm into a hospital, which I think is probably a pretty good rule. So she entered the vehicle at 8:27. At 9:18, Harner returned, and when Harner returned, he opened the door and yelled at her to get out of his vehicle. After a brief struggle, Liska grabbed Harner's pistol and shot him in the neck and ran off. Harner survived, though the bullet injured his carotid artery and struck his spine. And to sort of flesh out the rest of the story, Liska was arrested the next day and eventually pleaded guilty to the shooting and was sentenced to 20 years in the slammer. So at trial, Dispatcher Barry acknowledged that she could have seen many of these events if she had reviewed the surveillance footage, which, although she had been instructed to do that, did not do. The jury returned a verdict for Harner and found $2 million in damages, and Mercy filed a motion for judgment notwithstanding the verdict, which the court overruled, and so they appealed. In reviewing the court's decision on a motion for judgment notwithstanding the verdict, the court determines whether the plaintiff made a submissible case by offering evidence to support every element necessary for liability. And it's important to point out here that in inspecting this, they look at only the evidence favorable to the plaintiff. So if on a disputed issue, for example, in this case, like whether or not Liska was dangerous, if the plaintiff had evidence of danger and the defense said, well, we have evidence that, and we put evidence in the record that she wasn't dangerous, they would only look at the plaintiff's evidence. So it's a very deferential standard of review as to the jury's verdict, and that's the way it really should be. So they view the evidence in the light most favorable to plaintiff, and they don't supply missing evidence. In any action for negligence, you have to establish that the defendant owed a duty of care to the plaintiff, and that issue is the issue in this case. A duty of care arises when there is a foreseeable likelihood that particular acts or omissions will cause harm. And in this case, the particular act or omission is, on the one hand, the lady not reviewing the surveillance footage, and on the other hand, them not doing a more thorough search of the parking lot to find this character who was running around getting into cars and taking things from cars. So they say the touchstone of a duty is foreseeability, and it's measured by whether or not a reasonably prudent person would have anticipated the danger and provided against it. As a general rule, businesses have no duty to protect invitees, which basically just means patrons or people who come there to do business with them, from the criminal acts of unknown third persons. This is because such activities are rarely foreseeable. It's hard to predict when a criminal is going to strike. There are limited exceptions to the general rule, however, when special facts or circumstances render injury foreseeable in a given case. One such exception may arise where a business knows or has reason to know that a third party is harming or is about to harm an entrant. So, under the known third person exception, a duty may arise when a person known to be violent is present on the premises or an individual is present who has conducted himself so as to indicate danger and sufficient time exists to prevent any injury. So what do we have here? The only issue here then is based on the Wooldridge report, whether Mercy knew Liska was dangerous prior to the shooting, and that in such a way that a duty would arise in that situation. And the court essentially looks at some other cases and says that's not going to happen. There's a gas station case where people did not act dangerous, but then came in and shot one of the people who was there applying for a job. And they said that because they hadn't acted in a manner indicating they were about to become violent or dangerous, there was no duty. Similarly here, Liska did not act in a dangerous or threatening manner until Harner yelled at her when he found her inside his car. Prior to the shooting, there was no evidence from which Mercy could have known Liska would become violent, as she had not engaged in any verbal or physical altercations on Mercy's premises. While it is certainly sad for a gentleman who got shot in the neck and suffered serious injuries, the bullet hit his spine, that's a pretty serious injury. The fact is, there really was no way for Joplin to know, or the hospital in Joplin to know, that this person was out there, and she didn't have a firearm. She wasn't armed at the time. The only time she became armed is when she grabbed Harner's pistol and used it against him, which is something that I have talked about numerous times to groups, and I think even on this channel. If you're going to have a firearm in a car, you need to keep it in a gun safe. And there are fast-action gun safes that you can get for your vehicle where you put your fingerprint on the reader and it pops open and you can grab your firearm if you need it. But if you just leave it in your vehicle without securing it in some manner, somebody's going to bust that window out and take that gun every time. And in this case, they used it against Harner. It doesn't say anything about whether or not there were allegations of comparative fault here, meaning, hey, if you hadn't left the gun there unsecured, you wouldn't have gotten shot. But I think if I had been Mercy, I would certainly have made those arguments in this particular case. The bottom line is, this is a good decision by the Missouri Supreme Court, and it certainly sounds to me like there should not have been any duty on the part of the hospital, because you can't read people's minds. You can't know, looking at somebody who came to the hospital in an ambulance, that later on they're going to steal a gun out of someone's car and shoot somebody with it. So, again, a good decision. That's what I have for you today. If you have any questions or comments, feel free to leave them in the comments down below, or as always, you can certainly email me. If you have the opportunity today, do something nice for someone. We are taking our extended family today to a place called Callaway Gardens. Many of you may be familiar with Callaway Gardens if you've been to the South. It is a big golf course, but it also has a lot of other activities for the family. And every year they decorate that place with thousands of Christmas lights. And they have all manner of different sorts of Christmas decorations hanging. They have a little market where a lot of times you can buy locally produced things like jams and jellies and that sort of thing. So it's a very nice thing to do, and it's a great way to start celebrating the Christmas season. So we're doing that for the family tonight. Really looking forward to that. Thank you so much for watching and for being here and being a member of the channel. And again, if you have the opportunity today, do something fun, do something nice, reach out, share the joy of the Christmas season, and be back here tomorrow and we'll talk about something else interesting.
If you like this video, here are a few others you might try, and don't forget to subscribe. Have a terrific day, guys.